employer to conduct genetic monitoring of an employee unless the employee voluntarily complies, even if the employer might be able to meet a job-related standard of proof. GINA does not allow for that. So the question that then arises, of course, which is not addressed in the NPRM, and we feel it's essential that it must be, is what steps an employer can take if an employee fails to give consent to testing. Can the employer remove the employee from the location that they're working to a separate location? If so, what changes can they make to make sure that they are not interfering with the discrimination provisions of GINA? Whether whether they can make any modest salary changes as a result of changing their location, or any of the other type of changes that might occur when you move an employee from one location to another. We felt that the NPRM needs to address this possibility so that employers who are faced with the situation of an employee who doesn't voluntarily consent to genetic monitoring for toxic substances in the workplace, that they have a framework for acting. There is another exception having to do with law enforcement and human remains quality control purposes that I think Susanna might address quickly.
Sure. This is an exception that was added in the final weeks of deliberation over GINA, which provides, basically allows law enforcement or human remains laboratories doing genetic testing as part of their work to continue what is essentially a quality control practice of testing their employees for a limited set of genetic markers in order to be able to identify contamination problems with the samples that they are processing. So we think this is a legitimate version of genetic testing that's not going to implicate an employee's health risks for the future. And in our comments, we recommend what is the right sort of process to use genetic testing in this way, that it should be a limited set of markers that don't include health-related information. The employee's DNA sample should be destroyed after a designated period of time, and the sample and the results should be kept for quality control, not for any other purpose. And as with all the other exceptions in this area, to the extent an employer does obtain the genetic information, does acquire it, that information still may not be used to discriminate and has to be kept confidential.
And finally, our comments address the firewall between Titles 1 and 2 of GINA. And for those of you who aren't familiar with the firewall, essentially, and this came rather late in the development of GINA and was really the sort of the last essential negotiation that led to the passage of GINA. And the intent of the firewall is to, or at least ostensibly the intent of the firewall, is to create separate causes of action for claims under Title I and Title II, so that a claim arising under either title would be addressed within the title, and that you could not engage in what is often the case in civil litigation, the kitchen sink approach, so where you would essentially sue everybody as a result of a claim and let the court figure it out. In this type of situation, a claim under Title I, according to the firewall, generally would be brought against an insurer with the remedies that are available in Title I, and the claim under Title II would be brought against an employer with the remedies that are available in Title II. And what the EEOC and the NPRM made sure to clarify, which was a source of potential concern for us and was alleviated by the NPRM, was to make sure to note that an employer is not immunized from liability under Title II when they make an employment decision based upon information that is protected under Title I. This would be a situation where, for example, an employer, which is probably one of the most likely situations where an employer would discriminate, and that is where an employer would discriminate based upon health insurance information derived from a health insurance inquiry or that arose during a health insurance situation. And an employer who's made an adverse employment decision based upon that type of information under the NPRM is liable under Title II and has the remedy, and a claimant would have the remedies available under Title II in pursuing such a claim. So that is a good thing. The one thing that the NPRM does not address, and we felt was important to note, were situations where an employer would engage in an act that influences an entity under Title I to take an adverse action. So, for example, and this would largely be situations where you would have large employers, employers who have significant financial advantage within their relationship with their insurance companies, who might put pressure on the insurance company to make an adverse decision. The NPRM doesn't address that situation. And in that situation, the actual decision would be made by the insurance company and therefore be governed by Title I and the remedies under Title I. We felt it was important because we believe that it's within the keeping of the intent of GINA that an employer who attempts to influence an insurance company, for example, to make an adverse decision, that they should also, the employer, be responsible for under Title II for engaging in an act that was discriminatory under Title II. So we felt it was important to address that type of situation. With that, I can end my general comments and open this for a discussion and questions, and we welcome any thoughts that you have.
Okay, great. Thank you so much, Jeremy and Susanna. That was a wonderful overview, and I think it inspired quite a few questions on our end. And so I'll try and weed through those. Some of them, there are quite a range of them, so we'll try and kind of take a stab at them as much as possible. Let's see here. In particular for employer-based coverage, let's see here. There was some confusion expressed by a couple of participants with regard to, and I think it has to do probably a little bit with that firewall piece, so we'll start there, with regard to exactly the interaction with GINA between Title I and Title II with regard to when you're receiving insurance through your employer. If you can just try and give sort of a brief overview of exactly how that interaction works, I think that would be helpful for our participants.
Sure. You know, I think it's probably fair to say that with the exception of the kind of extreme circumstance that Jeremy just laid out, where an employer that is providing health insurance attempts to influence the health insurer, for the most part, any health insurance that you are receiving through your employer is governed by Title I of GINA. The employer may be the administrator of the health plan directly or indirectly. It may be paying some portion of your premiums or not. But it is the health insurer doing the underwriting to determine the premium costs that is regulated by Title I. Title II, for the most part, deals with hiring decisions, firing decisions, promotion, training, those sorts of decisions. What we wanted to do, and what I think Jeremy did a nice job of doing, is lay out the possibility that an employer could use sort of as a stick the benefits that it provides in some way. But that is, I think, more a consideration for who you would sue rather than what law applies immediately. So to put it maybe more simply, whether you get your health insurance through your employer or not, GINA means that the health insurer cannot discriminate against you on the basis of the genetic information, and Title I is the law that applies.
I would add that the distinction between Titles I and Title II comes down to who is the decision maker and what is the decision. If the decision maker is the insurance company making a decision about regarding your health care coverage, whether or not that company provides that coverage through your employment, that is governed by Title I. If the decision maker is the employer making a decision about any number of issues regarding your employment relationship, hiring, firing, promotions, etc., that would be governed by Title II. And then, of course, who is in terms of acquisition of information, the same distinction applies. Whoever is acquiring the information would depend on which title governs.
Okay, great. Thank you so much, you two. One question that I do have from the audience with regard to the Notice of Proposed Rulemaking, there's a mention in the NPRM of retaliation or an anti-retaliation provision in Title VII of the Civil Rights Act. Can you two just really describe how that applies to GINA? And Jeremy, I think we're still getting just a few volume problems on our end, so if you could just be sure to speak into your mic, I think that'd be helpful.
Sure. GINA, the employment provisions in GINA, aside from the definitions, which are relatively quite new to employment law, the bulk of the provisions in Title II of GINA are consistent and mirror existing civil rights law. So many of the provisions that you would have in Title VII and the Americans with Disabilities Act, Age Discrimination and Employment Act, and others are present in GINA, and the retaliation provision is one of them, meaning that, and generally, if an individual, in this case an employee, brings a claim under GINA against an employer, that employer is barred from taking any adverse employment action as a result of that employee pursuing that claim. That's a relatively common standard within civil rights and employment law, and it is present in GINA as well.
All right, great, thank you. And then one question I think really was brought up with regard to public versus private information, and kind of thinking about social networking and how information is shared now. Because more and more employers and their employees are on Facebook, can you maybe almost even use, use Facebook as an example of how, or I mean, there's Facebook, MySpace, and then you can go down another spectrum with sites such as Patients Like Me or other ways that people kind of organize and share information that might have that already kind of idea that genetic information could be shared on one site versus another. But could you be a little bit more specific in terms of talking about social networking sites, especially because I think that was a particular area of concern for some of our participants?
Sure, and the intent in this comment is to make sure that this exception, the exception for commercially and publicly available information, is read in a limited fashion. In fact, that's sort of the idea that runs through all our comments on these exceptions, is to make sure that these exceptions are, as intended, read in as limited a sense as the drafters intended. As many people are, I'm sure, aware, exceptions can often swallow the rule if they're not crafted carefully. And we felt that it was important under this exception for commercially and publicly available information to make sure